Hi, this is Zach Perry, attorney with the Fortune Law Firm. I want to talk with you today a little bit about the medical license protection that we offer here at our firm. To do so, we have to go back in time a little bit to get an understanding of where the problem we're trying to fix arose. We have to go back to the 1980s. In the 1980s, there was a problem, or at least a perceived problem, of bad actor doctors causing harm in their state, getting in trouble for it, and then moving to a new state where they could turn over a new leaf and start afresh. There was not really a mechanism in place at the time for the new state or some hospital they were seeking privileges at to become aware of their past. So to fix what they perceived as a big problem, the United States Department of Health and Human Services established a national databank. It is called the National Practitioners Databank. The idea was to create a registry where any bad actor doctors' names could be recorded, where other states could see it and respond accordingly. However, as well-meaning as this was, and in fact it was branded as healthcare integrity and protection, in reality they cast way too wide of a net. Let me talk to you a little bit about what I mean by that. Essentially, your name as a doctor can go on the list whether you've done anything wrong or not. I want to give you an example, because in the law, there are circumstances where a doctor may be financially responsible for something that happened, even though the doctor did nothing wrong. One such example is direct versus vicarious liability. Direct liability is just being held to account for your own actions. So if you harm someone, you are responsible for that. That's easy to understand. Vicarious liability is a little bit different. Vicarious liability is a legal principle that allows someone who is harmed to hold more than just the wrongdoer accountable based on some relationship. And a doctor is responsible for the actions and the harm caused by those working underneath them. That means that there are circumstances where the doctor can be legally responsible or financially responsible even though he or she has done nothing wrong. So the law says, doctor, you're not at fault, you've done nothing wrong, but you still have to pay for it. That is not something the databank recognizes, because whether the doctor has done something wrong or not, if a payment is made on their behalf in response to a claim, their name gets reported to the National Practitioners Databank. So I want to talk to you a little bit about this databank because, as I told you, it was established supposedly to protect the healthcare system, but in reality it treats doctors more like the plague. So here's how it works. If a medical malpractice payment is made or there's a report to the state board, a doctor has an obligation to self-report this. In many cases, the reporting is automatic. If a doctor fails to report, there are steep consequences. The doctor almost must self-report certain things to the DEA. And then the data bank releases this information to hospitals and insurance companies. So whenever you're seeking re-credentialing or privileges, and the re-credentialing process for insurance companies happens once or twice a year, your name is going to get pinged, and if it's on the data bank, then whoever is pinging it is going to become aware, and depending on what they're pinging it for, it may have consequences for you. This becomes a black mark on your reputation, a long-lasting one. There are several consequences of having your name reported. You could get denied when you seek credentialing. You could lose or have limited privileges. Certain health plans may not allow you to participate. Your malpractice insurance premiums could go up, or they could deny you coverage altogether, and then your medical license at the end may be limited, or you could even lose it. Now in our country, even criminals have rights. In fact, accused criminals perhaps have more rights than any other category of people. The Constitution guarantees accused criminals the right of confrontation, cross-examination, the right to present evidence, the right to a jury trial, the right to an appeal. There are all sorts of due process rights. They can often also seal their record so it doesn't come up again. But doctors whose names go on the database might as well be criminals without rights for the way they're treated. There are no due process rights. You don't get the right to a hearing. to present evidence, to an appeal, to confront your accuser. You can't get it sealed. There are virtually no due process rights. And once your name goes on the list, it's permanent. It's like the sex offender list, but for doctors. It is a black mark on your reputation forever. So at the Fortune Law Firm, we've developed a program in cooperation with some very smart doctors and lawyers to try and identify vulnerabilities of doctors, and in particular, circumstances when those doctors' names might be reported to the Databank. And we've tried to identify ways that doctors can maneuver within the complicated legal structures that they might be exposed to, including lawsuits, without having their name reported. So the first thing we looked at were several exceptions to NPDB reporting, because there are very particular and published triggers that require reporting. The first one is when payment is made out of personal funds. It's only when a payment is made on a doctor's behalf after a claim is made from a third party, payment by a third party is made, that reporting is mandatory. So often doctors will settle cases and they'll pay out of their own money. They will write a check from their personal bank account to pay the plaintiff, even though it costs them tens of thousands of dollars or more, because they know that financially and otherwise they're much better off paying from their own funds than having their name on that list forever. That's hardly an ideal situation though, because the idea is for doctors to have rights without having to pay exorbitant sums for them. The second exception we identified was if the practitioner wins the lawsuit. So a medical professional that gets sued and fights to the bitter end and goes to trial and wins does not have to pay and does not have to have their name reported to the Databank. But that's hardly a plan, because you can't count on winning. Moreover, you probably don't want to go to trial. As evidenced by the numbers, 95+% of all medical malpractice lawsuits settle before trial. Not to mention the risk if you do go to trial and you lose. Not only do you have to pay the lawsuit, not only does your name get reported, but if you get a runaway jury and the verdict exceeds the amount of coverage you have in medical malpractice, then you're personally on the hook, doc. The third exception we looked at is if settlement is made without written demand for payment. Now that's something we can capitalize on. Your relationship with your patients are contractual in nature. They agree to pay for services, you agree to provide services. So we want to review your contract and we want to make it more robust. We want to make sure that there are provisions in there that will allow a doctor to settle a case without written demand being made by the plaintiff. If the plaintiff never makes a written demand for payment and a settlement is made, it does not have to get reported to the Databank. We also provide protections in the contract so that if they fail to attempt mediation, you can get their lawsuit dismissed for failure to adhere to the procedural and contractual prerequisites of litigation. So you might just win your case before it even gets off the ground. The fourth and last one I want to discuss with you today is an exception made if a settlement is made and payment is made by a third party, not on behalf of you, doctor, individually, but on behalf of a hospital, group practice, or clinical practice group. So what we are going to do is we can actually set up a clinical practice group for you. It's not that complicated. There are some requirements the National Practitioners Databank puts in place for you to be classified as a group practice or clinical practice group, but we will take care of that for you. One of them is a corporate resolution. Another is you have to participate in an annual chart review program. You have to submit at least 5 of your charts to be reviewed by a peer, another doctor in a similar field, and he is or she is going to check those charts and make recommendations and comments so that your charting procedures are more robust. That is not a standard of review. They're not second guessing your decisions. All they're doing is making suggestions for better charting procedures. So if you can fulfill those 2 requirements, then you can classify as a clinical practice group, and then you can settle a case, have payment made on behalf of your clinical practice group, and your name is not reported. So those are 2 exceptions that we can make available to you, but these have to be done ahead of time, not after the fact. And for this process, one of the most valuable things we'll do is if you do get involved in a claim or lawsuit, we will coach your defense attorney who does not know any better. The defense attorney is hired by and paid by the malpractice insurer, and their goal is to get your case settled for as little money as possible or dismissed. They have no regard and no care for whether your name gets reported. In fact, many defense attorneys are not even aware of the Databank or of the long-term effects it has on a doctor's reputation if they're reported. Now, there are other vulnerabilities as well. We've pretty much talked about how doctors are vulnerable to their patients, but there are also employee vulnerabilities because employees do stupid things sometimes. They are handling controlled substances. There may be harassment going on in the workplace. So we want to make sure that we shore up those vulnerabilities so if your employees do something, you are protected. Same with partners. Up to a third of all state board complaints are originated by partners, almost always during the purchase or sale of a business because they feel jilted or they feel burned somehow, and so they report their partners based on behavior they understand is going on that is a violation of the board. So we want to make sure we protect you there as well. So we've really just tried to identify vulnerabilities and create tools to prevent where we can lawsuits from happening, and where we can't, give you the tools to be able to defend yourself and prevent your name from getting reported to the Databank. We are the Fortune Law Firm. We are the second opinion. If you're interested in learning more about our medical license protection program, you can schedule a free consultation with me direct at fortunefirm.com/Zach.